YNW Melly's first double murder trial ended in a hung jury back in 2023, but these 7 explosive moments had the courtroom on edge. All right, boys. Since the holiday's around the corner and not much is going on, I'm going to watch some old trials over the course of the next week. I don't know how many videos I'm going to make, but look out for a bunch of new videos of previous trials. I might even do some big trials that I didn't watch ever, like the Johnny Depp trial, other big trials that I've never seen. Let me know if you like that in the comments. Hit subscribe. Let's go, boys. Do you remember anything the defendant said on that video? Not for me. No, I don't. So, this is Melly's girlfriend's mom, obviously, and the prosecutor's questionnaire, and she just said, "Do you remember what the defendant said on the phone?" 'Cause remember, apparently Melly facetimed them right after the murders in the bush in the woods. You have an opportunity to read the statement. You gave in 2018. I read the statement. Okay, I don't recall. I don't remember anything from that statement. But I do remember my deposition from December 22nd, the deposition that would have been 6 months ago. Yes, okay. You remember speaking with law enforcement in December of 2018? I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone. Okay, so, Miss Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them? I would hope so. I mean, it was 2018. I went through a lot during that year, so I'm not sure where my mindset was at that time. I remember that answer. I would hope so. Did you lie to law enforcement? I would hope not, but I don't remember. I don't remember what I said. That was like 5 years ago. Oh, of course. Of course. I understand. It's been a long time. So, in terms of the time frame, that was closer in time to the incident of October 26th of 2018. If that's where you guys are saying it is, you don't even remember. I don't remember. I said 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on. So, of course, I was really out of it, okay? And in terms of your conversations with the police officers that morning, yes? I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after the fact. I do remember that, yes, and in terms of she's talking about Moretti, obviously. Bullying her daughter because he wanted her daughter to snitch on me. Statements that you made about what happened. You don't have any recollection of. Did you read this statement multiple times? I looked at it and I just didn't recall it, and I know. And so you indicated you hoped you were truthful with law enforcement? Yes, I did. I have to ask you to be more definitive. Were you truthful? I don't remember what I said to them back then. So if I was to tell you something now, I could be lying. I don't want to lie to Stan because you're going to take me to jail. So I'm saying what you want me to say. I do not want you to say anything. I want you to tell the truth. Okay, that's what I'm doing. Okay. So it's kind of a smart way to get around admitting if you were lying back then. Like, I don't remember, but I hope I was telling the truth. I'm just telling the truth now. That's all I know. But do y'all really think she forgot if she lied to the police? I mean, I would remember that if I lied to the police. In terms of your appearance here today? Yes, you don't want to be here. Yeah, you don't want to be here. You made me come here? I did. But yes, and in terms of you were served with a subpoena, never served me. And so you were never served me. Y'all heard that, right? That's going to come up, I think, in the witness tampering trial. By the way, the main defense that Melly's lawyers had in the witness tampering was that Mariah was never served. So how is he witness tampering someone that was never served a subpoena to go to trial? As we all know, I ain't no damn lawyer. I don't know how that works. The state was still able to charge him with a witness tampering. So I don't think that really matters, apparently. If you're new to the channel, please hit subscribe. I appreciate the support. Back to the video, boys. Ordered by the court to show up. You never served me originally. That was a lie. And in terms of your job? Yes, did you quit your job? I got fired because you put me in jail. And prior to that? Yes, before you were put in jail, did you quit your job? No, okay, so you never quit your job? I had to leave because you were told my lawyer were going to put a warrant out for me. So I had to leave my job, okay, so you left your job? Yes, so as you can see, she's very pissed off because she lost her job, understandably. So the whole subpoena thing is very interesting. And now her mom isn't coming back for the second murder trial. I think I remember reading that somewhere. Hearing that somewhere in all the videos I make now about this underscore, I think it was one of the hearings. Felicia Holmes is not being called as a witness in the second trial because they saw how terribly it went. Is it your statement testimony that you never stated the promises that were made to us by YNW for me to quit my job and they would take care of us for all lies? They didn't want us talking with prosecutors, but now they've all disappeared. You've never said that before. I don't understand. You hear that? So that's why she questioned her about quitting her job, because apparently the Melly camp promised to pay her pretty much. Objection, Your Honor. Move for mistress. Thank you. Melly's lawyer said objection, move for a mistrial. I forgot that when you first took the stand, you said I feel threatened. Yes, sir. I do. Who do you feel threatened by your rules? Christine Bradley, the prosecutor's office. This prosecutor? Yes, I did. Thank you. Do you feel threatened by me? Of course, okay. Did you fail to appear for numerous court appearances? No, you never served me. Lied. Okay, you even went so far as to hire an attorney to try not to show up? I sure did. And has the state offered you any money? The state's basically has me on a monitor. I have to go to my job with this. It's embarrassing. People think I'm a criminal. The state has ruined my life. And in terms of your feelings and ill will towards the state and myself, I just feel like innocent people. And does that influence your testimony today? It's not influencing my testimony. I'm telling you. Excuse me. Hold on. Only one of you can talk at a time. This is going so bad cause even if what she's saying is not true or true about quitting and the Melly underscore, it makes the state look like bullies. And that's what I think I was saying in my first videos. It all depends on how the jury sees it, though. So, Miss Holmes, in terms of the court order that was issued, you're aware that that was found to be valid? No, I'm not aware of that at all. Okay, you hired an attorney to go and represent you before this report. He had to hire an attorney because trying to get him in his bar. And that's false statement. Objection. Excuse me, counselor. You're not testifying. You excuse me. You asked a question. All right. That's it. You asked a question. She crossed the line there. I mean, even if she knows that that is a lie, she can't say that's a false statement. As a prosecutor, like, you can't say that. And so with regards to that, you hired an attorney, yes. And you then tried to get any sort of court order requiring you to be here in court thrown out. No, what I did was I hired an attorney because you were saying you served me in the subpoena, that you never served, and that was signed to be valid? You never served Mr. Penn, that was you never served me. I've never seen a subpoena those address that you said you served. Those are not my address. Your testimony said you have never been served to appear in court, and that's the answer. And so with regards to your feeling threatened on that, have I ever off any sort of physical violence against you? I will. Do you have any written threats from me? It's intimidating. You've intimidated me this whole time. Now, bro, Felicia hates Christine Bradley, bro. So, Miss Bradley said that the subpoena was valid. So that's how I guess they were able to charge him witness tampering. So who's lying here? Was this subpoena ever served or not? What do you think? She's saying she wasn't at that address or it's not her address. You understand that you were served a subpoena to appear here today? You serve a subpoena after you arrested me at the jail. And you understand you were here pursuing to that court order? I'm here. And that requires under the law to comply with court orders too, and that compel? I've been complying. Okay, nothing further. All right. And then here's the moment where Mel's lawyers ask for a mistrial witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible instead of at least admitting that that was what the state intended to do, would advance a ruse pretext through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done. And it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible EV. Playing games. And also, these lawyers aren't on this case anymore. Ain't that crazy to think about? The next trial is not going to have any of the same prosecutors or lawyers at all. Crazy to me. And they launched into that pursuit. Mr. Demons has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2. Questions with the implications that were being all predicated on the implications and the inadmissible testimony that Miss Bradley herself read into and spoke into the record. For that reason, we think that it was deliberate. It is highly prejudicial. This jury has been tainted and removed for a mist. All right. So this next amendment is about printing documents. Yes, you heard me correctly. Printing paper. I can't. I don't know how this is real. So can you make copies for those? I found all of them. If there's one that she's missing, I'm happy to do so. Pull them up again. I printed them all this morning for suggesting she doesn't have them. So I just want to make sure she has, of course, and that's not a problem. But they've all been turned over via email. This is all in there. The original copies as well that were provided. Counsel does not have the ability to print something out in the courtroom. Now she's asking, Counsel Raven Liberty is asking for a copy of it. Let's provide her a copy. I'm happy to do so. I just need to know exactly which one she says she's missing and which one she says she has. I don't want to have to duplicate them if it's possible. None of the documents she's published. Give me a courtesy. Print all of them out. All right. You're going to make copies of all the documents. So she has in her hand some of them already. So I just want to make sure I don't double print. Just double counsel is suggesting she doesn't have them. So let's just print them all. This prosecutor, do you see what I'm saying here? All this prosecutor to do is be like, I'll just double print them all. Yeah, so they can't say anything. And that's what the judge is even saying. Double print them, please, just to cover all bases. So I just want to make sure I don't double print. Just double counsel is suggesting she doesn't have them. So let's just print them all. Okay, well, she does have some, I don't know. You're saying they're sent. She's counsel suggesting she hasn't received those things. I just want her to get copies of it. I don't want the your constant back and forth. Well, she has to just get her the copies. That's it. It's easy. Just get her the cops? How is that real, bro? What an absolute clown chow. Now, here is a discovery violation situation apparently about evidence violation. There's a discovery that's ongoing. You know about it, and you're not telling them about it until we're here in court. So, as far as I can already concerned, I think that's a discovery violation. And I'm finding it to be a discovery violation. That the only way that can be cured is he's not going to testify about this second procedure. That happened, that's not coming. Not coming in from the same thing if you want to keep investigating a case, you can do it. You can find exculpatory information, may change your mind as to how you proceed with the case, and I don't have a problem. You investigate whatever you want to investigate, but as far as using new discovery that you're coming in, I think a cutoff needs to be, because this is what's going on. We're going to have this. If you find something new, there's a hole, as counsel described it, that you try to find evidence to plug up the hole, and that's new discovery. The defense doesn't have an opportunity to depose the witness. Defense doesn't have an opportunity to do X, Y, and Z. That's just not the way it should be. It shouldn't be done by surprise. Is that not the most calm you've ever seen a judge telling a prosecutor do their job correctly? No more surprises for defense lawyers. Give over everything. So it's clear this was not a new item. This was just this. All of the information was supposed to be identical. You found it? You did. You had a meeting with the detective in May when we're in hiatus 'cause I'm on vacation. All right. Got a meeting with him in May after we picked a jury. And when we're ready to, or we're in the middle of jury selection, you did it and you said, well, he tells you, or you ask him, do you have more, programs to go ahead and provide the information, and you find out there's another program and he runs the program, does a different download with something other than Cellite, and therefore you have more information. Don't make the defense aware of it. You hold that to yourself. You go ahead and put on a couple weeks of trial testimony, and then when it comes up after he, in cross-examination, points something out, or you bring it up and say, well, by the way, I told him, a detective, in our pretrial meeting it came up, and he has the program and we can use it, and we're doing it all right, so he ran 2 different programs on a phone or something for Cellbrite, I don't know, but what the prosecution should have did there is give over even the second run of this other program. Clearly you don't tell them about. Just go ahead and hold it. Keep it close to the vest yourself. Don't explain it to them. And then you say, when it comes up at try, say, what was it? I don't have the report yet. That's why I didn't turn it over to him, but didn't disclose it's coming. It seems to me that's not what's supposed to happen. Not supposed to happen, period. That's a discovery violation. Okay, so as far as the Detective Moretti, and whatever other form he used, that's not coming in. Okay, all right. That's the sanction. If you have other information, other discovery that's in the works, you better share it with them, because right now, if you don't have it, they're not aware of it now. It's not coming in unless there's something extraordinary that pops up. And just because, you find out that they have additional capabilities and you want to go retest something, that's not extraordinary on my way of thinking. I'm not familiar with what the case law says. It just seems to me that this is a fundamental fairness thing. You have evidence, you need to turn it over to him. If you didn't turn it over to him, you can't use it. That's really the basic. And yeah, that's basics 101 when it comes to evidence in a capital murder death penalty trial, right? There's also evidence that we have that establishes that phone was being used. The phone comes up as the name Sackhazer Howard. Sackhazer is the nickname of one of the decedents. That phone is used interchangeably so much that when you dial with it, it comes up with one of the decedent's name as the identifier. It's in the name of Jamie King, not Jamal Demons. It was retrieved from Jameson Francois, not Jamal Demons. So I remember all this. They tried to say that it wasn't Melly's phone. That was, I think it was 7,908 number, something like that. I thought I remembered the number for a second. I don't know if it was. It was his phone. And I said this throughout the trial. It's the defense lawyers trying to smokescreen on saying it's not his phone and deny it's his phone, but it was his phone. I mean, there's pictures apparently of him having sex on the phone or videos. Would you put videos of you clapping cheeks on your friend's phone? So it's neither in his name. It wasn't retrieved from him, and it comes up with an ID. It was being used after the defendant was arrested. That's a red flag. Who was using Melly's phone after the arrest? That's sketchy, definitively. It shows a phone being used to call. It shows the same step data from that very unit after he is incarcerated. It's obvious that it's being used by several other people. We can't even say that it's his phone, and the information there is therefore all relevance. All information on it is non-hearsay because it's a statements of the defendant. Not only is it being used by others to text, to call, being carried by others, it's in somebody else's name, retrieved from someone else. The phone was located, it was taken from the defendant's manager on February of 2019. The defendant was providing the passcode and information via jail calls to his manager to use it on that. And the phone also authenticates itself in terms of every single photo that is on that. Wait, Melly had to give his major the password on jail calls. Clearly, it's his phone. I mean, oh man, that's so funny. A selfie, a screenshot of a FaceTime conversation, or anything of that goes back to this defendant. Then they have to establish it before they put it in, not after the fact. This Instagram account is being used and accessible to a number of people. This notion that, oh, it's his account, he's an artist. It's a public account that several people have access to. I'm sure you're going to be able to ask those type of questions. Counsel, my thought is this, counsel. It's not fair to basically give me an inch worth of things to read, cases to read, articles to read, saying it's not the methodology is, and the basically Delbert issue on it. It's not a clear, it's not been established. All those types of things that should have been done pre-trial. I haven't seen what's on the account. I don't disagree with that. Counsel's telling me it's relevant because of X, Y, and Z there. You're saying it's not, but I don't know what is the 403 analysis. What's more prejudicial and probative? I haven't seen anything about that. I don't know what it is. I haven't seen it. You haven't made me aware of it. You're just saying something's more prejudicial than probative.